Welcome and thank you for joining us this morning. Our session, Navigating Dismissal Law Across Borders, Employer Insights from South Africa, Kenya, and Namibia is really an exciting topic. Employment law in Africa is dynamic and often nuanced. That's because Africa is not a single legal jurisdiction, as we know. It comprises over 50 countries, each with its own labor codes, some with constitutional provisions like South Africa, and each one with their own case law that's developed over a period of time. On the continent, South African employment law, for instance, is well anchored, and its jurisprudence continues to be referenced in other countries as a basis upon which to continue to develop and compare principles of employment law in those jurisdictions. Our session today is designed to help employers in three key jurisdictions to understand how to operate in them. That's namely South Africa, Namibia, and Kenya. Because we know missteps in areas like dismissal law often lead to costly disputes and reputational risks. Today, with Senior Associate in our Kenyan office, Daniel Kiragu, and Director in our Namibian office, Frida Kishi, we will gain an overview of the legal framework on dismissals in these regions, ranging from key areas, including types of dismissal, procedural requirements, specific grounds like misconduct, performance, redundancy, incapacity, probation, as well as best practices for mitigating and dispute avoidance. Before we get started, as always to everyone, just a reminder to please stick your questions into the chat, and at the end of the session, we'll pick up on those particular questions. Daniel, if we can start off with you, perhaps a useful place to pick up the discussion is to understand what is the legal framework which governs dismissals in Kenya.
Thank you very much, Imran. Thank you for the question. The legal framework in Kenya is built on several sources. The Constitution of Kenya 2010 provides for, Article 41 provides for fair labor practices. Article 47 provides for fair administrative action. And this anchor is what usually governs the treatment of employees. And then we have the statute, which is the Employment Act of 2007, which is the primary statute that governs all aspects of employment relationships, including termination, especially sections 41, 43, 44, 47, and 49. We also have the Labor Relations Act of 2007, which governs collective bargaining, union membership, and industrial action. Especially, this is relevant for unionized workplaces. We also have the Employment and Labor Relations Court Act, which establishes a specialized court with exclusive jurisdiction over employment disputes. We also rely on judicial precedent. These are decisions which have been made by the Employment and Labor Relations Court, the Court of Appeal, or the Supreme Court, which are binding and interpretive. Now, sometimes we borrow from Commonwealth precedents, like from South Africa, from the UK, but these are persuasive, particularly where there are gaps or ambiguities in the local law, or a novel issue which requires, referral to a different jurisdiction. Back to you.
So Daniel, I'll just point out that South Africa left the Commonwealth a long time ago. We were quite proudly left the Commonwealth. But,
it's not necessarily only Commonwealth. We can borrow from jurisdiction outside the Commonwealth as well, but only at a persuasive level.
I'm quite conversant in or have come across South African jurisprudence in Kenyan law. So authorities in Kenya that specifically make reference to South African law. So do you find that quite often in the Kenyan jurisdiction?
Our jurisprudence has actually quite developed mostly, so we rely mostly on our own precedents. However, like I said, sometimes there are gaps or there's some novel issues that have been litigated maybe in South Africa and not in Kenya, where we can borrow the decisions.
Fair enough. That's interesting. Thanks, Daniel. Frida, if we can move across to you to understand what the legal framework is which governs dismissals in Namibia.
Thank you, Imran, and thank you for having me. The main law is the Constitution of the Republic of Namibia, 1990, which promotes fair labor practices in terms of Article 95 thereof. We have the Labor Act 11 of 2007, which sets out the particular provisions that specifically relate to specific instances. And then equally, we do have case law that is also quite developed, and we do borrow. And I was not sure if Daniel was speaking about Commonwealth or common law, but my understanding is that it's the common law, which would have been the Roman Dutch law as well as the British, the countries that are relying on the British law. So we are definitely, where there are gaps in our system where we cannot find authority, we also do make use of the South African authority and rely on that. So those are the three main areas that is governing our labor framework. I must mention that as well as sub laws, which is the code of conduct, obviously, that will set out the internal legal environment in any entity. Thank you. Back to Imran.
So Daniel's reference, Frida, to the Commonwealth, I guess is related to both South Africa and Kenya's colonial history and involvement in the Commonwealth through the British Empire. So I guess that's where that comes from. Our relationship with Namibia in relation to the common law arises out of English and Roman Dutch law. So I guess that's where we find the similarities in our law. So through the Kenyan line, through the Commonwealth, and in relation to our own history, that would relate to Roman Dutch and English law because of where our own histories come from. So the legal framework in South Africa is quite complex in the sense that since 1994, the Constitution, our Constitution, the democratic Constitution, at least since 1994, entrenches the right to fair labor practices. So we've got that written into the Constitution, which provides a very broad protection in relation to employment rights. But sitting together with the Constitution, or what's also important outside of the statutes, are the contract. So a contract is quite important in our law, and it's something that's generally somewhat overlooked, but superimposed upon the contract are the various statutes that deal with employment law generally, and the Labor Relations Act superimposes its statutory protections on fair labor practices which come out of the Constitution. So that's essentially where our statutes meet the contract, and then we've got many years of jurisprudence that's then built on the principles of fair labor practices, and since 1995. A very well-developed source of authority through both the Labour Court, Labour Appeal Court, and I would say over the last maybe 10 to 15 years through the Constitutional Court as well. So a lot of employment dismissal disputes have actually made their way to the Constitutional Court. Daniel, if we can then talk about what Kenyan law refers to the two-test approach in determining the fairness of a dismissal. How does that actually operate in practice? So firstly, what is the two-test and how does it operate in practice?
Thank you very much. Just before I answer your question, I just wanted to mention that the employment contracts are also very important in Kenya, and the HR policies or the handbook. And one point to note is that in Kenya, the statutory provides the minimum requirements. So if you have contracted with the employee and have provided for higher standards or higher benefits, then you'll be held to those higher benefits and not the statutory minimum.
Yeah.
All right.
That's interesting. Daniel, if you just stop on that point, I mean, that's very similar to South Africa in relation to dismissal protection. So we share that with Kenya. What about Namibia? Frida, is it a similar sort of approach?
Yes, contracts should not be in conflict with the law, which is the governing laws, your constitution, as well as your Labor Act. So you can negotiate, I believe, for better terms, but not for less favorable terms. That goes against the provisions of the Labor Act as well as the Constitution. So contracts are definitely very important. And in preparing this, I've realized that even if you go to the discussion of probation, that we'll later get to, we don't really specify what is required during a probationary period and how it is dealt with. And I would think that employers should start looking or start contracting deeply or making clear the provisions or specify the provisions under which an employee is contracted and what the probationary period requirements are. But we will get into that discussion when we get to that issue.
So Daniel, if we get back to the two-test approach, so let's just start out. What is the two-test, and then how it plays out in practice?
Yes, so Kenyan law uses the two-test approach. You could probably think of it as, for example, a twin-engine aircraft model for dismissals. So the first engine is substantive fairness. So one, is there a valid and justifiable reason for the termination? So it could be poor performance, it could be misconduct, it could be whatever reason, but is it a valid and justifiable reason? Then the second engine is procedural fairness. Was the process compliant with the law? This is Section 41 of the Employment Act in Kenya. In that, the procedure here is that have you issued a notice? Have you held a hearing? Was the employee represented during the hearing? And in Kenya, a failure of one engine renders the whole dismissal unfair. So the focus is not on proving that the employee is wrong in Kenya. The process is proving that the employer did everything right.
Okay. So it's to keep your analogy, it's almost like a Boeing, I guess. 747. You've got to make sure it's both aligned, otherwise you end up with an unfair dismissal. So let me just understand that, Daniel. So if a dismissal is wanting from a procedural perspective, so it's procedurally unfair, that would render, but substantively fair, would that render the entire dismissal unfair?
Yes. So one failure of one renders the whole dismissal unfair. What will happen is, for example, if the reason is substantive but the procedure was wrong, then the entire dismissal will be held unfair. However, during the awarding of compensation, the fact that the reason was valid will be a mitigating factor to the extent of the quantum being awarded, but it will still be rendered unfair and unlawful.
Okay, interesting. Frida, from the Namibian side, what's the equivalent? Is there an equivalent in Namibia?
Yes, Section 33 of the Labor Act provides for the dual requirement for dismissal. It must be similarly substantive fair, and the procedure should also be fair. I don't want to repeat what Daniel has said, but maybe let me go on to the point of procedural fairness. I realize that a lot of employers think that fairness or the procedure only starts at the period of issuing the notice and when the internal disciplinary process starts. I have started advising employers to actually look into the process from the moment that a misconduct has been reported. When you go into your investigations, you need to make sure that audit, which is one of the principles of fairness, has been complied with. Already at investigation stage, you have to involve the employee. So the process must be fair, and is case law stating that where your investigations were not fair, where the employee was not involved or consulted during the investigations, that could render the process unfair and hence the dismissal unfair. So it is quite important to look into your process from the moment that a misconduct has been reported.
Yeah, so that's quite interesting, Frida, because this concept of investigation and inquiry. So what Daniel was referring to, procedural fairness in the inquiry stage, pre-dismissal. In our code of good practice, the South African code of good practice, which in fact we just had a, let's call it a refreshed code of good practice since early September 2025. There's a reference to investigation or inquiry. And I suspect we're going to find some development in South African law on that distinction, investigation or inquiry. So it's quite interesting that there's due process in the investigation stage in Namibia. And is the authorities on that in the Namibian jurisdiction, or is it just kind of best practice that you're referring to?
There are actually cases that speaks to that I think the particular issue that I was dealing with was whether the employee, when the external investigations, and most of the time you will find that companies might be using forensic investigators to investigate a report, whether the investigator at the time of executing his investigations did consult the employee. And where it was found that the employee was not investigated, the court was of the view that that the process was unfair because they were supposed to be given a chance. They needed to understand what the charges against them were. They were supposed to be told. And when I had that discussion, one of the employers stated, but that chance is given at the hearing, and that is not what the courts are saying. Yes, that is at the second stage of the proceedings. That is when you institute the hearing. But when you are investigating, there are certain questions that only the employee who was involved would most probably have answered and clear up some issues. So the courts definitely have looked into it and found that that could render the process unfair if the employee was not involved.
Okay. I mean, the point that you made, Frida, was the one I was going to say to you. The fact that the employee is not given an opportunity during the investigation stage, which is quite extraordinary, but be that as it may, does that not mean that the employee would have an opportunity at the stage of the inquiry in any event to put up a position? But you're saying that the courts find that you, as an employee, have the opportunity to make representations both at the investigation stage and at the inquiry stage.
Imran, the question is, how could you get to the finding that you get if you did not even consult the person that is involved in the so-called or the alleged misconduct? That, I think, is the crux of this whole ruling of the courts, that the person must be consulted when investigations are underway. So there are instances where disciplinary hearings would most probably not even have proceeded if the employee was just asked simple questions. I want to make a simple example. For instance, where somebody has been charged for taking a motor vehicle of the company without authorization, but where most probably the CEO had asked him to do that without consulting his supervisor. Supervisor lays the complaint and a misconduct is held, but he has never been asked. What happens then at the end of the day when we come to the hearing and he said, but listen here, I want to call the CEO. The CEO was the one who asked me to do him a favor. You know, that could have been ascertained or discussed or dealt with at the time of investigations. So it is very important and very paramount that at that stage of investigations, the employee has been asked. Money has been lost, or money cannot be found or cannot be accounted for. You have to involve the employee for him to explain that. So you cannot have sort of a one-sided investigation and not involve the employee, even if he's going, because at the hearing stage, obviously, the charges have been laid and he has to answer to charges. But at the initial stage, it's more an investigation to determine if there is sufficient ground for the substantiveness of it to charge him at the end of the day.
So let me test the proposition, and I do it as obviously as a South African lawyer. So we've moved, I would say, over the last 15 years or so into what is called now a decriminalized process in South Africa, right? And there's a lot of history associated with that. But we're currently in a stage in the development of our law in what is essentially called an informal decriminalized process. So as a matter of I follow it almost as a matter of logic that you should not get to an inquiry without first hearing the position of the employee, almost as a matter of logic. But there are instances where an employee is not given an opportunity during the investigation, but may only be given the opportunity during the inquiry. There may be certain instances where that becomes justified. So what we've got in South African law is that the investigation may actually constitute the inquiry. It seems to me, Frida, I'm putting words into your mouth, sorry, on a Monday morning, not a cross-examination, I promise you. But is there a world in Namibia where an investigation almost becomes the inquiry, or is that an absolute no-no?
Not necessarily. I think that the idea of Audi at investigations is for the investigator to understand what is the version of the employee, to enable him to have an informed report at the end of the day. So the fact that the employee is confounded is not a hearing. And we've actually had discussions where an employee will come and ask, or the investigator will say, I did inquire from the employee, and this is what is explained to me. And I think the way that this is even dealt with will get to a point where we will be required at the end of the day to have notes on investigations and to note down what the employee has advised at investigation stage, because that also becomes evidence during the hearing. So I don't think it's an in-depth of investigator asking questions and cross-examining the employee, but it's more an issue of the investigator getting an explanation from the employee on the allegations against him.
Interesting. Daniel, do you want to weigh in on this aspect from a Kenyan perspective? So the investigation inquiry phase, could they be melted into one process, or do they have to be two separate processes in very formal settings, or can they be, as I refer to, a more decriminalized process?
Thank you. Well, I definitely agree with Frida. But in Kenya, we have the statutory framework, which is the minimum required standard. And in this minimum required standard, you have to, what is required is that you issue a notice on whatever allegations to show cause on the allegations. Then you give the employee an opportunity to respond to that notice to show cause, giving their explanation. Then once he has given their explanations and maybe there is an investigation done, then a decision is made maybe to invite them now for a disciplinary hearing. Now, if they're invited to a disciplinary hearing, again, they have an opportunity to make their representations, to come to be accompanied and make their representations again. And then after that hearing again, then a decision has to be made by the disciplinary panel. Now, there are instances where you have contracts which have other standards. For example, if you have contracted the employee that, there's suspension first, and then there's an investigation that happens, and then all this is supported, but this is outside the minimum standard. So in that situation where you have the suspension, then they could be asked to make representations before even any official disciplinary action is taken in terms of issuing the official notice to show cause.
And on the notice to show cause, so this commences the entire process.
Yes.
But let's just park for the moment the contractual bells and whistles. In other words, an employee has more than what the statutory requirement is. During that process, does the employee have the opportunity, for instance, to say, well, your notice to make cause makes no sense to me, and I want further particulars, as lawyers would say? Would an employee have the right under Kenyan law to do so?
Yes. So once the notice to show cause is issued, then they are asked to respond. If they need more time, they are given more time. If they need to access evidence, they are given that. They are given all the reasonable accommodations to be able to respond to the notice to show cause. And then once they have made all their representations, then the employer has to decide, is it sufficient, or should now move on to the next stage, which is now inviting them to a disciplinary hearing.
Interesting. And is this all in writing, or is it by oral representation?
So the law requires that this be in writing. However, it also provides that the same can be made orally in a language that the employee understands.
And at this stage, does the employee have the right to representation, and what sort of representation?
So at this point in time, well, in Kenya, you have a right to representation in terms of a lawyer, but in terms of making representations, that happens during the hearing. So when now a decision is made to invite the employee to the disciplinary hearing, they are informed of their right to be accompanied by either a fellow employee or a union representative if they're unionized.
Okay, so there's no automatic right to legal representation.
It's not there, but the courts have made recently decisions that even in the disciplinary hearing, if the employee requires a lawyer comes in, that if it does not prejudice the hearing in any way, then it should be encouraged, because it maybe reduces the disputes that end up in court.
Okay. And just a final question on this issue of procedural fairness, as it were, Daniel, because I've got some. I just want to mirror that with Namibia and South Africa before we move on to substantive fairness. On average, how long does it take for an inquiry to run then in Kenya? I know it's a difficult question, but a ballpark, a couple of weeks, couple of months.
In Kenya, it actually takes sometimes a couple of days, as long as there's reasonable time for the employee to make his responses. They may request for extensions. Then once that has been made, a decision can be made on when the hearing date is. Reasonable accommodations are made on when all parties are available, and so it can be pretty fast.
Okay, that's interesting. Frida, in Namibia, from what Daniel has said, does it mirror what happens in Namibia, or is it very different?
Not exactly the same, because he is speaking to a process in between investigations, and it will appear before the DC. They would they will give the employee a notice to show cause. We do not have such a process. If the employee have preliminary issues, those are normally dealt with. Once investigations is completed, the notice is sent out for the disciplinary inquiry, and at that stage, I think that will answer the question that you have asked earlier. At that stage, and if there are questions that they would like to raise pertaining to the charges, we raise that as preliminary issues before we go into the merits of the disciplinary inquiry. And they would normally raise if they are if the charges are unclear, or if they need information that is dealt with prior or during the disciplinary hearing, but as a preliminary process prior to delving into the merits of the charges.
Yeah, that's. Sorry, Frida, I interrupted you.
No. You spoke about the time period. So because we don't have the notice to show cause period, it's dealt with in the same process as a disciplinary process. So you could take an hour or two to have this discussion. However, if there's a requirement to advance or provide some information, you might adjourn for the initiator to provide the opponents or the employee's representative information. And that will be a couple of days for them to sort out the preliminary issues. But we had instances where you open up the laptop for the employee, they go through the information, or we even had instances where people are ordered to share information, like in bundles of information. Yeah. And once that is shared, it takes a day or a couple of days. Once it's shared, then everybody comes back and indicate that their concern or complaint has been cured, and we will then start the disciplinary hearing. But this whole process forms part of the disciplinary process, and it speaks to the right to be adequately prepared, the right to have sufficient information, and all those rights that are part of your procedure of fairness.
And I guess to understand what the complaints are against the employee, it essentially gets to that. So it's interesting that our laws kind of moving away from that formality, because for a long time it was an old trick that when an employee received complaints, the disciplinary complaints, that what would happen, there'd be a lengthy request for further particulars in the internal process. And then there'd be requests for documents and additional documents. And, all of these sort of stuff would ultimately result in delays in the inquiry, et cetera, et cetera. So we've moved away from that sort of levels of formality to a more informal process. But our laws actually become, to a large extent, has been tainted by what happens in the public sector, has impacted the private sector to a large extent. And because the laws in the public sector are so regulated by statute, those statutory protections kind of formed its way or found its way into private sector employment debates that kind of murkied the water over the last 30 years, which kind of created the problems that we've seen over the last number of years, which is essentially where we are at a point where we're trying to get away from the more formalistic processes that I guess that you're referring to. I've got one last question, burning question in relation to procedure, and then we can jump into substance. Daniel, perhaps if I can ask you this: the chairperson of the internal inquiry, who is that typically? Is it somebody internal, somebody external?
No, thank you. In Kenya, mostly the most common practice is to have the disciplinary panel is usually an internal panel. So this is composed by the employer, by people who are within the organization. However, it's still allowed to have an external chairperson. The main thing is that there is fairness and there is no bias.
Right.
So therefore, the person who accuses cannot be the same person who is in the panel, and cannot be the same person who decides.
Frida, in Namibia, same principle.
In Namibia, it depends on two factors or more than two factors. I think the main one is what is the ranking of the rank of the employee that has been charged. If it's a person of a lower rank, normally your codes of conduct might be speaking to the supervisor, being the one initiating the process, and the supervisor or someone in their rank above the accused employee could do that, which is the internal chairperson. But if it's a senior person, normally, and if the matter is complex, the entity's employer is inclined to get an external representative, and sometimes, obviously, an attorney or maybe a person with expertise on the subject matter of the misconduct. But it can be either. I have seen at times they also appoint a committee instead of appointing just one chairperson. Some disciplinary codes of conduct makes provision for the appointment of a committee that contains one or more than one person. I think it should be an unequal number if there's a time, obviously, for the committee to chair over a hearing.
Interesting. I'd love to chat about appeal processes in all of that, but let's just stop there and talk about substantive fairness. In South Africa, we've essentially got three categories of dismissal. So that's misconduct, incapacity, operational requirements. Daniel, in your jurisdiction, are those the recognized types of dismissal, or are they more restrained?
Yes, I think the similar types of buckets of dismissal types. We have the summary dismissal. This is usually happens when there is gross misconduct. Then we have ordinary termination. This is with notice. because the summary dismissal is usually prescribed as one with less notice than is normally required. Then we have another way of terminating employment could be through a redundancy. Then there are also claims, a resignation, which can lead to a claim maybe for constructive dismissal. So those are the main similar types of terminations that also happen in Kenya.
Thanks, Daniel. Frida in Namibia.
Yes, it's exactly the same. When it comes to misconduct based on poor health or incapacity, or operational retrenchments, redundancy, and what he has mentioned about, that is quite also common, the resignation that he has referred to, a person who resigned and based it on
intolerable circumstances.
Constructive dismissal.
Yes. We desperately going to run out of time, but I'd just like to ask you about incompatibility. Daniel, does incompatibility often arise as a form of dismissal, or does it generally not?
Thank you, Imran. Incompatibility is a reason for for the employer to seek termination. However, it's very rare. So if the employee, for example, is not a cultural fit, really the main thing in terms of terminating any employee is that you have to remember the core safeguards. You have to really justify that as a reason, and how that affects the operations of the company. So it is it's not a common ground. However, if it arises, then you're supposed to follow the same procedure where you justify the reason to be valid, and show how the incompatibility is affecting the role, and also follow the right procedure.
Frida, you started out on probation, which is beginning of the employment relationship. Perhaps if we can pivot to that. Just talk us through probationary periods generally in Namibia, in the termination related to probation.
Thank you, Imran. I think employers had this understanding that once you have contracted an employee and the contract of employment made provision for probation, at the end of the probation period, they would have the view that since your probation has come to an end and we do not want to retain your services, we are therefore going to end your employment based on the fact that your probation has come to an end. But it's not as simple as that. And I've mentioned earlier that we do not really spell it out to the T in the employment contract of what is the process of probation entailing and how should it be handled. And that contract, or at least something additional to that, should be communicated to the employee to make him sensitive or make him aware of the fact that during this process, you are actually still assessed to determine that at the end of this process, the 3 months or the 6 months of probation, we will have to make an assessment and determine if you were fit for the job that you have been contracted for. So it will require that, I believe, certain KPIs, your JD is clear to the employee, KPIs are set out, and the employee is at least consulted or have meetings to just talk to them, especially when you pick up early in the process that this person is not coming to the party, he is not being able to perform, then you need to do that. And if you look at the procedural requirements, there are some of them that actually overlaps with the process of poor performance as well, because this assessment speaks to performance. So you have to do assessments, you have to have the hearings, and it would appear, which I am speaking under correction, that you need to assist in terms of giving a bit of training also to help the person if they're struggling. But at the end of the period, it's also just not as simple as, listen here, you were not able to perform, hence we are making you to leave. You need to have that discussion, you need to have that meeting, sort of a little hearing before you let them go, but it's not as formal as the disciplinary hearing or a hearing based on poor work performance. So at the end of the day, if you decide to terminate, the employer has the right, in my view, to ask for reasons why his probation was not confirmed, and you need to have reasons. And obviously, you need to have followed at least a fair process. Fairness is the cornerstone of all disciplinary proceedings. So you need to be able to justify your reason for termination, and then obviously that you followed some form of process when you came to the end of this, or when, yes, to the end of the process, of the end of the, or at the termination of the employee.
So Daniel, sticking with your Boeing 747 analogy, where does probation sit on this aircraft in Kenya? Similar, I saw you nodding your head as Frida's was making the case in relation to probation in Namibia. Is it very similar in Kenya?
Yes, thanks, Imran. I was nodding because I agree. In Kenya, before Section 42 of the Employment Act had provided that for probationary contracts, you would only issue a 7-day notice, and that was it. However, in 2021, there was a case, Monira versus Mount Kenya University, where a 3-judge bench held that excluding the process that is required for other employees was unconstitutional. And therefore, since then, even for employees on probation, you still need to do the same procedures if they are a permanent employee.
Wow.
So like Freda says, if it's performance, you need to do the appraisals, you need to do the performance improvement plan, you need to do the the reviews, you need to support the employee and show and document the additional training and support before terminating. So right now, there's no difference between an employee on probation and a permanent employee in terms of the procedure for termination.
Well, that's quite interesting, Daniel, Frida, because we again the South African law, or the standard in relation to probationary employees, is much lower than it would be for a permanent employee. So the test in relation to performance, one is lower. In the process pre-termination, as Frida said, is likewise similar yet different. It's again an informal process, one where an employee has the opportunity to be heard before either an extension of the probationary period or termination. So that's quite interesting. Let's talk about redundancies and retrenchments, Daniel. Just talk us through the requirements in Kenya very quickly.
Thank you, Imran. In Kenya, the terms are often used interchangeably. But legally, redundancy is what is provided for under the Employment Act under Section 40. And the key steps under this section is that you have to issue a 1-month notice to the employee and the labor law officer. If the employee is unionized, then you also have to issue the notice to the union. Then there has to be consultation. This is usually a 30-day notice. Then you have to do consultation with the employee and the unions in terms of this role. Now in Kenya, it is the role that is declared redundant. It's not the person. So it has to be the role. And then after the consultations, in these consultations, you're supposed to try and accommodate these employees maybe in other roles within the organization. And if this is not possible, then after the period, then you can be able to terminate on grounds of termination. But the procedural requirements are very strict, that you have to issue the notice simultaneously to the employee or the union and to the labor officer. Then when you're selecting the people to be redundant, you also have to apply the selection criteria that I think this goes across board in terms of the skill, reliability, seniority, last in, first out, and this kind of selection criteria. And this has to be documented. The metrics that the criteria that has been used to select the employee has to be documented, so that if there's a claim in court, the employer is able to prove why they chose this person, not this other person. You also have to pay the dues that are required or are due to the employee. This is severance pay, leave, any accrued leave, notice, in lieu of notice, and the severance pay is usually 15 days per each year worked.
And Frida in Namibia, just very at a high level.
Yes, equally, Imran, our equivalent act, section is Section 34 of the Labor Act that speaks to redundancy based on economic reasons or a transfer of business or discontinuation of business. Equally, a process must be followed. We also have a 30 days period, which must go to the employee, the union involved, as well as the labor commissioner. Consultations with the employees are very critical. You need to have a consultation with your various meetings with the employees to look at less drastic measures, in the sense that whether the closing of the business or the redundancy is the only options, you look at alternatives. And then at the end of the day, as he has indicated, once an agreement has been reached, then obviously there are certain benefits, there are benefits that must be paid out to employees, which is the severance. Equally, also here, 7 days for each year, continuous year of employment. And then obviously you must pay out your leave days. If, like in the current or the recent instance of USAID closing and giving a notice that offices must close within 24 hours, there was a notice in lieu of the 30 days notice that you normally would have given. So those are the type of benefits that must be paid at the end of such a period.
Let's just talk about challenges to dismissals generally. So Frida, in Namibia, firstly, where are challenges heard? Is there a specialist tribunal? Does it go to a civil court, or is there a labor court? And what's the time period for a referral to the tribunal?
Once the internal process has been concluded, and you said you would love to go into appeals, but we didn't go into that. Obviously, you must conclude internal process, then you conclude your appeal process, then the employee has 6 months to lay a complaint with the labor commissioner. And that should be within 6 months. If it's not done within 6 months, then definitely it lapses.
So there's no condemnation after a 6-month period. There's a time bar.
The Act says it lapses.
Okay, it's interesting. Daniel, in Namibia, in Kenya.
So in Kenya, there is also a time limit for employment related claims. It's 3 years. This is for events that are, for example, termination. So any redress is sought at the Employment and Labor Relations Court within 3 years. However, for continuing injury claims, these are claims, let's say, to do with underpayment or such injuries that maybe happen regular on a monthly basis. For those type of claims, you only have 12 months to file your claim. After 12 months, anything that happened after that is bad.
So again, both Namibia and Kenya has a strict time bar after a period of time, no condemnation, is understanding. Go for it.
Yes, sorry, apologies. There is a condemnation opportunity after the 6 months. It says it lapses, but it's still, I believe, you can follow a condemnation application.
Interesting. So the South African position is there's 30 days within which to refer from the date of dismissal. Right. So you've got 30 days from date of dismissal to refer to the tribunal. Alternatively, all matters have to go to the tribunal first for conciliation. So there's first conciliation and then arbitration thereafter. So in arbitration is within 90 days of a failed conciliation. Either it goes to arbitration, or depending on the nature of the dismissal, it goes to the labor court. So it's 30 and then 90 thereafter. And we've got condemnation provisions after the expiry of the 30 or the 90 days.
Imran, for Kenya, there is no equitable extension. So once the 3 years are over or the 12 months are over, the court cannot extend.
It's interesting. What about conciliation provisions, Daniel? Is there no statutory conciliation before a court process, or is there?
So there is in the contract there could be an appeal process. Also, there is also a recourse to the labor office where the employee could, especially this usually happens for unionized employees, they make their complaints to the labor office where conciliation meetings are held and a conciliator is appointed.
Okay, interesting.
Then if there's no resolution, they revert back to court.
Is it a requirement, or is it something that's it's elective in the form of the contract? So it's not a statutory requirement, in other words.
Yes, it's not just, you see, for example, the unionized employees usually have collective bargaining agreements, and those provisions are usually there.
Yeah.
And but for normal employees, the recourse is usually to the courts. However, they can still make reports to the labor office and follow that conciliatory route.
Okay, interesting. And Frida, in Namibia, on the conciliation part.
The conciliation in Namibia takes place before the Office of the Labour Commissioner. That is the first process, and the purpose of conciliation is for the parties to reach an agreement. Only if the parties are unable to reach an agreement, then they move into mediation. Our court is more a court of appeal. Once an award has been made at the Office of the Labour Commissioner, that is when the aggrieved party can lodge an appeal with the court, which is the Labour Court. So we start with the Labour Commissioner's office after the internal process, and the processes at the Labour Commissioner are first conciliation. Once it fails, then you go into the arbitration.
Okay, got it. So I just want to close off on our discussion before we pick up some of the questions in the chat. Let's just talk about the remedies post termination. So Daniel, in Kenya, what sort of remedies are available to a dismissed employee? You're on mute, Daniel.
Sorry for that.
No right to be heard. Or Daniel said no right to be heard.
So in Kenya, under Section 49 of the Employment Act, the court may award compensation, which is usually up to 12 months gross salary. There's another remedy, which is reinstatement or re-engagement, which is very rare, but it's provided for. There's also, can be awarded, the employee can be awarded, his terminal dues, this is a notice pay, if not pay, the leave days, gratuity, if it's contractual. And there's a requirement that each employee must be given a certificate of service. So this is really one of the claims. And the court has to consider several factors in terms of the main award, which is a compensation of 12 months. So they have to investigate, look at the mitigating factors, whether there was valid reasons, even if the procedure was not correct, the conduct of the employee, the likelihood of, how quickly the employee found alternative employment, because here the main goal is to compensate the employee and not to punish the employer. However, in cases where there is, for example, constitutionally protected infringement, for example, if there's discrimination or sexual harassment, the court sometimes goes above and beyond and can award exemplary damages or punitive damages for that.
So punitive damages would be in excess of 12 months, in other words. It will be outside of the compensation order.
Yes.
Interesting. Frida, in Namibia, remedies?
Namibia, the courts make provision for reinstatement, compensation, and obviously any other benefits that goes along with that, which is your leave payout, your severance payout, and any other benefits that the employee would have been entitled to. But I think the main two are reinstatement as well as compensation.
So Daniel, we share that with Namibia, which seems very contrasted to Kenya. So under South African law, reinstatement is the primary remedy. So on an unfair dismissal, so we, unlike your Boeing, we almost, I don't want to call it the Airbus, but we certainly have a distinction between procedural unfairness, substantive unfairness, and you can have a finding of procedurally fair, but substantively unfair. So you can have a split in an outcome. On substantive unfairness, an employee can ask for reinstatement, and if there's no basis for a substantively fair reason for the dismissal, reinstatement can be ordered, and they can be back pay with that. So that's quite different from your jurisdiction. Frida, you wanted to make a point before we get into the questions.
Yes, the idea is to place the employee in the position he would have been had he not been unfairly dismissed. That is the crux, I think, of compensation or reinstatement. Reinstatement at the end of the day.
Yeah, that which kind of finds it's perhaps the principle is similar to ours. Our principle is reinstatement is the statutory primary remedy, but for the conduct of the employer, in effect, in a substantively unfair dismissal, the employee would not have lost their job. So I guess the principle kind of finds its place. Daniel, Frida, thanks very much. I wish we had a whole day. I guess we could speak about this for another hour and a half to the end of the day. But there are some interesting questions that have been raised. If I can just pick up some of them. It relates to the ILO convention, and the question is, in Kenya and Namibia, I'm delighted to say nobody's asking about South Africa. Is Kenya and Namibia a signature to the ILO convention and the recommendation concerning the elimination of violence and harassment in the world of work? So perhaps I'll start it out. We, as in South Africa, has a code of good practice in relation to, let's call it, anti-harassment in the workplace, but it's not promulgated under the dismissal protections. It finds itself under our anti-discrimination law protection. So we are signatory to the ILO convention, and it's now found its way into our law. Frida, does Namibia have an equivalent anyway in its employment law?
On the 9th of December 2019, 9th of December 2020, we became the third member for the to register under the ILO. But we, unlike South Africa, did not yet adopt the Code of Good Practice. I have also heard Daniel speaking about many other laws than the Labour Act. I think we need to emulate with South Africa and Kenya and introduce more of this, because the Act is very general and very broad. But definitely a lot of work must go into specifying specific areas and giving it more detail. So we do not have a code of good practice. I have seen your code. I have used it at times just to guide myself, but we don't have a similar one in Namibia.
Okay. Thanks, Frida. Daniel, on the Kenyan side.
Yes, thank you. In Kenya, Article 2 of the Constitution allows for ratification of international treaties, and Kenya is a signatory member of the International Labour Organization and has ratified conventions. Therefore, yes, we do have similar or usually borrow from ILO.
Okay, so the final question, Daniel, is posed to you, and I'm going to read it to you. It says, based on court precedents, how many days in Kenya are considered fair to be given to an employee to respond to a show cause letter or to prepare for a disciplinary hearing? So show cause letter or to prepare for a hearing, what's the time period?
So in Kenya, like I said, it depends with the circumstances of the case. So if the issue is something that could be responded to, within a day or two, the same could be fine. If it is a complex investigation that requires you to give more time to the employee to make their submissions, then you accommodate the employee. So as long as it's reasonable, it's allowed. So the employee could ask for extensions, and you're supposed to accommodate that to a reasonable extent. So it could be, it depends with the circumstances of the issue at hand.
Excellent. I love it, Daniel. It's one way to start the week. A fresh week is with a lawyer's answer reasonableness, depending on the circumstances. So, Frida, Daniel, I started out in the beginning of this session saying that it was an exciting topic. I think I should have said it's going to be fascinating and very insightful. This has been a delightful discussion with yourselves. I honestly wish we had a little more time to delve into the detail, because I guess a lot of the devil lies in the detail. But Daniel, Frida, thanks for the time, for having this discussion with us. It's interesting to see the similarities yet differences in our jurisdictions, but the golden thread being one of fairness, which permeates all three jurisdictions. And it's really been an exciting discussion. Much appreciated. And to our participants, as always, we thank them for their participation and involvement in this webinar. Wishing you both a good day ahead.
Thank you very much.
Thank you, Imran.